Hello, back again after a short break at my end. We're on the home stretch now. I think we left off at this slide, and we were talking about conflicts of laws, and that's really what I want to finish off with today. So, as you know, the area of conflict of law, also known as private international law, deals with cases where the laws of more than one jurisdiction might be applicable. Sorry, I'm a bit tongue-tied because I literally just recorded this lecture without turning record on the video. So I'm doing it for the second time, so hopefully I don't rush too much. We'll see how we go. So as you know, this happens in situations like where marriages or divorces that involve partners from different countries, or inheritance matters across jurisdictions where assets are across jurisdictions, or where there's a death in one country and the assets are somewhere else. It can also happen clearly in international business transactions, and that's going to be our focus. So the primary goal of having conflicts of law rules is to determine which jurisdiction's law should apply to a given legal issue, and how judgments from one jurisdiction can be recognised and enforced in another. So the key principles we're interested in are jurisdiction, choice of law, and recognition and enforcement of judgments. So let's actually, with no more hesitation, let's continue on. Now, I want to say we're going to spend a bit of time thinking about how the court will answer these questions, but the best solution is to make sure that the court doesn't need to solve this question, that as transactional lawyers, and for reasons that you'll see as we explore the cases, there is real benefit in ensuring that your contract clearly specifies both the forum and the choice of law, in order to ensure that you can enforce the judgments. Now, the cases ultimately come back to this, and it's that tug that we see in contract law all the time between express and implied terms. If we have an express term, we are significantly more likely to get what we expect, even if ultimately we might be better off in a different jurisdiction. So just to recap, choice of law is about determining which country's law should be used to interpret the contract and to resolve the dispute. And choice of forum is about deciding which country's courts will be used to settle the dispute. Now, this forum question is necessary because every country has its own set of rules for dealing with this kind of conflict. So they're its own kind of conflict of law rules. And these rules help courts figure out which jurisdiction's laws are most appropriate for resolving contract disputes. Basically, there's no global one-size-fits-all set of rules for these situations. Each country's conflict of rules are different. Conflict of law rules are different, making international contract disputes even more complex and expensive. So basically, we often start with this kind of mini trial to determine the most appropriate forum, the most appropriate set of rules, before we even get into the actual matter under dispute. Key case here is Akai and the People's Insurance Company of a Hong Kong company. It's a 1996 High Court case, and I think you should read it, frankly. I think for a couple of reasons. Basically, we've got an Australian company and a Hong Kong-based company. This is 1996, when Hong Kong was still a British colony. Entered into an insurance contract that related to the movement of goods from Russia to Australia. So fairly complex fact scenario. It's a useful case though, because the High Court had to decide on the appropriate choice of law to apply, and in doing so, it considered a range of different factors, including the intentions, express or implied, place where the contract was formed, and the place with the closest connection to the contract. So it really sets out the tests that we use. It's worth looking at the way that it discusses the intention of the parties. So in that regard. The court emphasised the importance of determining the parties' intentions regarding the choice of law, whether explicitly stated in the contract or implied by the circumstances. It also looks at place of contract formation, so the location where the contract was entered into can affect the choice of law, especially if it significantly relates to the execution of the contract in some way. Sorry, just looking at my notes. And then the third thing that this is a useful case for is closest connection. So the court also looked at which jurisdiction had the closest and most real connection to the contract. Ultimately, it held that the proper law of the contract was the law of the place with which the contract had its closest connection. So this is an important element of that test. So, conflict of laws deals with three core issues that arise, as I'm just going to re-summarise here. The choice of the forum, where should the matter be heard? The choice of the law, what substantive law should be used to resolve the dispute, and the enforcement of those foreign judgments. The choice of law decision needs to be distinguished from the choice of forum decision, and I can't overemphasise that. So forum is the place in the jurisdiction in which the matter is heard, and the choice of law is what substantive law, set of laws, will be applied to resolve the dispute. So they're not mutually exclusive. A matter can be heard in a particular forum using the laws of another jurisdiction. So I want you to think about what the strategic implications for parties to a dispute of both of those conflict of law inquiries can be. An obvious problem, of course, is that the most appropriate choice of law and the most appropriate forum might be answered differently in different jurisdictions. So what an Australian court might answer using its conflict of laws might be different from what the courts of, say, France might answer using its particular rules. A really good example of this is in the Yahoo Nazi memorabilia case. I may find time in the tutorial to talk to you about that. But essentially the strategic battle, in a sense, is who's going to be the plaintiff first, because once you've got it into a particular forum, it can be much harder to extract it, and you're using the rules and civil procedure process in the forum where the action is first brought to determine what the appropriate forum is and what the appropriate rules are. Does your head in after a little while, right? So in Australia, we use the proper law of the contract rule, but in different places, so for example in the US, there are a whole heap of different choice of law methods: balance of interest, comparative impairment test, hybrid methods, and so on. Another important element of the Australian test is the concept of forum non-convenience. So kind of the seminal case here in a common law sense is the 1986 case of Spiliada, which used or proposed a clearly more appropriate forum test. And this was processed in much more detail in Oceanic Sunline and Fay, a case that you will probably remember from contract law. Basically, some passengers from Sydney sued in New South Wales for injury that they incurred on a Greek cruise ship. We look at it in contract law from the point of view of where was the contract made, because there was kind of a piece of paper at the beginning, a receipt, and you went and exchanged that in Greece for a ticket. The ticket included a limitation of liability clause that would not have been enforceable in Australia. Also, the Greek system, in order to sue in Greece, it was much slower. There were a whole lot of strategic reasons why the Fays wanted to bring their action in Australia. They were more likely to succeed. Ultimately, the High Court in Australia dismissed the appeal by the cruise ship owner, but it's a rather unsatisfactory judgment in a range of ways. The High Court wanted to provide clearer guidance on how to interpret forum non-convenience, and so we continue on and sort of think about that particularly in Voth and Manildra flour mills. So this is a 1990 High Court of Australia case, significant decision because it deals with the principles of governing forum non-convenience, the doctrine of forum non-convenience. And that doctrine allows a court to dismiss a case if another forum or jurisdiction is more appropriate for hearing the case. So in that case, Mr. Voth sued Manildra flour mills. Manildra basically said, no, we believe that there is a dispute, but the United States would be a more appropriate forum for it to be resolved in because the relevant facts, evidence, witnesses, everyone else was predominantly in the US. The High Court had to decide whether the Australian courts were an appropriate forum for the case or if it should be dismissed in favour of a trial in the US. So the case is useful because it discusses forum non-convenience. There's a significant analysis of the doctrine, and the doctrine allows courts to decline jurisdiction if there's a more appropriate forum. So it's essentially the court analysing a situation in order to determine whether or not it should stand aside and stay proceedings in order for that same matter to be adjudicated by a different court, a different forum. The judgment also looks at the appropriate forum tests. The court emphasised that the burden of proof is on the party seeking the dismissal to demonstrate that there is a clearly more appropriate forum for the resolution of the dispute. So the onus of proof in this particular set of circumstances was on the flour mill. The test involves considering factors including the location of evidence, the residence of the parties, and the legal and procedural disadvantages. So it's not enough for it to be inconvenient for a defendant to come and have a matter brought against it in Australia. There needs to be a range of different factors considered. And probably the meat of this is in the section discussing the stay of proceedings. The court set out the criteria in this case for when a stay of proceedings might be granted, indicating that it should only happen if the Australian court is a clearly inappropriate forum and if a substantial injustice can be done to the parties in the alternative jurisdiction that otherwise wouldn't be available. So it's not enough for it to be merely inconvenient. There needs to be a clearly inappropriate forum for the matter to be heard. So this case is pivotal because it incorporates a detailed examination of the doctrine of forum non-convenience. It lays down the principles for determining the appropriateness of a forum, and these principles have been influential in a range of subsequent cases involving jurisdictional disputes. The case itself underscores, if I can repeat myself, the importance of actually making sure that forum and choice of law are clearly articulated in the contract in the first place. So, choice of forum, a little bit more. In Australia, the test for determining whether an Australian court should hear an international commercial dispute involves looking at whether is it a clearly inappropriate forum. If it's a clearly inappropriate forum, a stay will be ordered. But how do we apply this test? Still cloudy as to we have a cloudy, not clearly inappropriate forum test. So usually an express choice by the contracting parties of a governing law will be upheld by the court. That's why we want to make sure there's a clause in the contract. But of course, there are many situations when it's not expressly stated or it's for some reason unclear. So then we go back to Akai. So Akai mentioned earlier, the High Court reviewed a range of the earlier case law to really identify, well, what is the proper law of the contract. Lord Diplock, in Amin Rashid Shipping and Kuwait Insurance, describe the proper law of a contract as a system of domestic laws which identifies the obligations, that is, the complex of rights and duties assumed by the parties to the contract. Contrast this with Bonnython, where Lord Symonds described the proper law of the contract to be, firstly, the system of law by reference to which the contract was made, Australian law, UK law, civil law, Sharia law, or, secondly, that with which the transaction has its closest and most real connection. So in Akai, we end up with this statement: there is in truth only one question here, and that is whether, upon the proper construction of the contract, which may include an expression of choice in direct language, the court properly may conclude that the parties exercise the liberty given by the common law to choose the governing law for their contract. If the answer to this is in the negative, the law itself will select a proper law. In other words, the idea of contract under the common law is a private law made between two consenting parties by negotiation, having all of the elements of a contract. It's a set of rules that the parties have agreed for valuable consideration that is not past consideration will apply to their dealings. And that liberty to create that private law includes a liberty to determine which laws will apply in the circumstances where there might be a dispute. So ultimately, this is kind of a combination of the tests in Diplock that Diplock and Symonds had in the cases that we just mentioned a minute ago. So there are problems, right? Okay, let's think about what the implications and problems are of the conflicts of law approach. The problem with private international conflict of law is that it can be abused by lawyers who want to forum shop, who want to drag out proceedings, or frankly generate their own revenue. We'll talk about this in the tutorial. I want you to think about whether you think these are problems. If they are, how can they be resolved? What is it that I'm missing here? And that's where I want to finish for our very first lecture. Yay! Second lecture will also be recorded on the road, most likely. We'll see how we go. And I am looking forward to seeing you, where we'll be discussing the kind of things we've talked about in this lecture in the week starting on the 11th of March, but remembering because the 11th of March is a public holiday, we will instead be meeting on the 13th, on Wednesday the 13th of March. It will be by Teams meeting. I believe that there will be a room available, and I will let you know when I know what that is. We'll do it as a kind of hybrid shoot, and we will talk about that soon. Cheers.